Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing self-defense laws in Canada. This is in light of a major case in the United States involving a young man named Kyle Rittenhouse. It's a case that captured international attention and has been hyper-politicized. If you're not familiar with the case, the very basic facts are these. On August 25th, 2020, 17-year-old Kyle Rittenhouse fatally shot two men and wounded another in Kenosha, Wisconsin. The shootings happened during protests, riots, and civil unrest in Kenosha, which had begun after the shooting of a black man by a white police officer. At trial, Kyle Rittenhouse argued that he shot in self-defense. Complicating the facts were that Rittenhouse had brought a semi-automatic rifle to these protests or riots as part of a group of armed men in Kenosha who said they were there to protect businesses from being damaged by the protesters and rioters. Further complicating things was the confrontation between Rittenhouse and the men he shot. Rittenhouse argued that he was attacked and feared for his life. Rittenhouse's claim of self-defense was ultimately successful, and he was acquitted of all charges. The case has led many people to wonder what self-defense laws exist in Canada. Was this a made-in-America case that would be impossible here? How do our self-defense laws compare? Here to discuss this is criminal lawyer Lawrence Gridin. Now, Lawrence, I tried to give a basic summary of those facts. I'm sure I've left out things that will make people on the right mad, make people on the left mad. I don't really take a position on this case. It's an American case. But is there anything you'd like to add to the facts that I outlined?
Yeah, I think it's important that if you look at the video, you get a pretty good overview, a good sense of what took place, because there is pretty decent video footage of what took place. And you do see Kyle Rittenhouse, the accused in the case, and he is, armed with a rifle, and he appears to be running away from a man who's chasing him. It's very clear that he's not the aggressor in the situation. He's running away. The man is chasing him. The man throws something at him. The man gets close enough to basically touch him. And that's when Rittenhouse fires. The really significant thing I think that people really had a problem with is that this was an unarmed man and Rittenhouse was armed, right? And he also brought the rifle to the situation. And
The first man that he shot was unarmed.
Right. And that's what sort of set off the whole chain of events. But, this was an unarmed man who was, I think anyone would agree he was the aggressor in the situation. And it's really came down to a question of whether it was reasonable to use deadly force in that situation to stop this unarmed man. I don't want to sort of weigh in and give my opinion either, because, we have very different laws here and we have different outcomes, I think, for cases like this. It's really an American case, subject to really Wisconsin law.
Yeah, so that's one of the things I wanted to talk about. This show is called Canadian Justice, so we don't need to parse the details of what happened in an American case. But can you give a broad sense of how self-defense laws work in Canada?
Sure. So, boiled down to the essentials, everybody has a right to protect themselves. I mean, that's a very basic notion. I think everybody understands that. Even small school children, on a playground understand this concept. And what the law basically says, the law reflects that. And it basically says that if a person reasonably fears that they're under attack, then they can use force to repel that attack to protect themselves. So if you have a good reason to fear for your safety, you can protect yourself. Now, there are limitations, there are nuances. It's not, quite that simple, obviously, and we probably don't have time to go into all the nuance on a segment like this. But in terms of claiming self-defense, the way it works is essentially if a person is charged with a crime, like an assault or a homicide, like they've shot somebody and they've killed somebody, if the evidence in their trial reveals that self-defense might be an issue, that they might have been protecting themselves, it's automatically raised. They don't actually have to fill out a form or check a box and say, I'm claiming self-defense here. If the evidence reveals that, then it's automatically an issue, and the Crown Attorney, the prosecutor, has to prove beyond a reasonable doubt that they weren't acting in self-defense in order to secure a conviction. And if the Crown can't do that, then the person's entitled to a complete acquittal. So it's going to be a very binary result. Either complete acquittal or self-defense claim fails and you're guilty of the offense.
And there are different parts of what is required to make up a self-defense claim. When we come back from this commercial break, I want you to explain what it takes to make out a successful claim for self-defense, what the elements are. We will be right back after this commercial break. Welcome back to Canadian Justice, where we're discussing how self-defense laws work in Canada in light of the Rittenhouse decision from the United States. So we're with lawyer Lawrence Gridin here. And Lawrence, I wanted you to outline what it takes to make a successful claim of self-defense. Traditionally, we've talked about elements like belief, necessity, and imminence as the key elements. But this changed in Canada in 2013. What can you tell me about these elements of the defense and how you can make that successful claim?
Sure. So you're absolutely right. The defense did change in 2013. It was a little bit more, shall I say, structured or black and white what the rules were. And now what the government has done after 2013 is made the law much more about just this sort of nebulous concept of reasonableness. You have to reasonably fear that you're under attack. You have to take some action to defend yourself from the other person or from the threat of force. And the act that you do to defend yourself has to be reasonable in the circumstances. So I've used that word reasonable a lot. And, I'm sure people are going to question, what does it mean to be reasonable? But it is, quite frankly, the answer is it's a very nebulous concept. It's not something that can be is just subject to hard and fast rules or checkboxes. The whole idea is a jury is going to look at the whole of the circumstances, the whole situation, and make a determination of whether it was reasonable to use force, the force that was used in that situation.
So what kind of things might make a belief reasonable? Does it have to be a correct belief? For example, if you believe someone is going to shoot you, but it turns out that they are unarmed. For example, in the Rittenhouse case, the first man that Kyle Rittenhouse killed was unarmed. So does the belief have to be correct in order for it to be reasonable?
So that's a great question. And the answer is no. You can be mistaken in your belief. The whole idea is that it's a belief. It's not about objective reality. What the jury is going to be asked to do is to step into the shoes of the accused person that used force to defend themselves and ask themselves, was it reasonable to fear for your safety in that situation? So let me give you an example, more concrete. If somebody points what appears to be a gun at you, and you decide to use force to defend yourself against that firearm, if it turns out that the gun was unloaded, or if it turns out that the gun was a replica firearm and was harmless, like there was no way you were actually going to be hurt, that's fine. You can still make out a claim of self-defense, because the whole idea of our criminal law and these defenses is we don't want to punish people for doing something that's morally blameless. You're not doing something morally wrong if you protect yourself against a legitimate belief that this is a gun, right? So we're not going to punish people if, on the objective facts, it was actually a harmless weapon. You are entitled to make a mistake. It's not on the basis of objective reality. And, in terms of assessing reasonableness, it's based on a huge list of potential factors. It's an unlimited list, really. What were the relative sizes of the two people? Was this person bigger than you? Were they martial arts trained? Are you martial arts trained? If you're martial arts trained, maybe it's not reasonable for you to use the amount of force that you did to repel an attacker. Was that person armed? Did you believe them to be armed? Did you think you had an avenue of escape? All of these kinds of factors. Was it in the middle of the night? Were you in a rural area where it was far away from the police? The response time from police was very long. All of these things come into play in the jury's assessment of what's reasonable.
So would proportionality of force come into play? Say someone is attacking you and they're unarmed. Would it be unreasonable to respond with a weapon if you have a weapon with you to defend yourself?
100% proportionality is one of the key considerations. The amount of force that you use to repel that attacker has to be proportionate, but proportionality, it just factors into that reasonableness assessment. There's no hard and fast rules. Let me give you an example. If you're a 100-pound female and you're, in a parking lot at night going to your car and a 250-pound male attacks you and tries to sexually assault you, you can absolutely use a weapon to protect yourself. No one's going to expect you to fight that person off with your fists. You're going to lose that fight, right? So, absolutely, you can use a weapon to defend yourself. And there's no rule that says if the person's unarmed, you have to respond with like force.
Super interesting. And what about the ability of escape? Does that factor in anything? I mean, we have 30 seconds. How does that factor in?
No requirement that you have to run away, you have to escape, but the availability of an option to escape is again something that the jury is going to consider. Was it reasonable to use force to repel the assault when there was this easy avenue that you could have taken? That's a factor that goes to the reasonableness.
Now, we have to go to commercial break, but when we come back, I want to ask you why the law changed in Canada, because it used to be a lot more similar to the law that actually exists in Wisconsin right now, the structured elements of self-defense. I want to ask you why Canada made this change, and if that change makes it actually harder to claim self-defense. We'll be right back. Welcome back to Canadian Justice, where we're discussing how self-defense laws work in Canada with lawyer Lawrence Gridin. And this is all in light of the decision in the Rittenhouse case out of Wisconsin in the United States. Now, Lawrence, in the last segment, we were talking about how the claim of self-defense that you can make to if you've been charged with a crime, that used to be a very structured kind of defense that you used to make, where you have these three elements you have to prove. And now it's shifted to this more nebulous concept of reasonableness, of all these different factors of reasonableness. Now, does this change make it easier to claim self-defense? Does it make it harder? And why did the government make this change?
So it's a bit of a funny story. In 2013, the government changed it. The Harper government changed our self-defense law. In theory, all they were trying to do was make the language a little bit more clear because it was very convoluted, and frankly, juries were getting confused by it, even lawyers were getting confused by it. So they were just trying to clarify it, touch up the language. Let's say, apply a fresh coat of paint but without changing the underlying structure. And the Department of Justice said that that's basically what they were trying to do, that they're just trying to codify what is the existing law. They're not trying to change anything. Unfortunately, the Supreme Court of Canada subsequently comes out with a decision that says that, the language actually changed enough that notwithstanding what the government was trying to do and what the Department of Justice says, the structure did change, and the law is now actually quite different. And it is a much more nebulous concept of reasonableness. So I don't think that was necessarily a real public policy choice. It's just sort of something that happened. It's just one of these sort of vagaries of the law, as opposed to a deliberate decision by the government. But to answer your other question, it is now, I would say, harder to claim self-defense. I think most legal scholars would say that with the more nebulous concept, there are more ways where a jury would find conduct to be unreasonable. It just opens the door to I think, more findings of guilt for people claiming self-defense on the margins.
Now, one of the things that was a big aspect of the Rittenhouse case was this idea of provocation and when you can claim self-defense, if you've actually provoked the attack, and how that claim of self-defense is limited. So, how does it work in Canada? How do the rules and laws around provocation of an attack impact your ability to claim self-defense?
Yeah, so prior to 2013, under the old law, provocation, if you provoked the assault, if you started a fight, basically, there were different streams that you would go down legally of whether you could claim self-defense and in what circumstances. That's all been eliminated. So now provocation just happens to be one of those factors. I mean, if you started a fight, doesn't mean you can't claim self-defense. There's no hard and fast rule, but it's certainly, again, something that the jury's going to look at and say, was it reasonable for you to use force to defend yourself when you're the one that started this fight? That's something that's going to factor into it.
And what actually would constitute a provocation under Canadian law? Is it, actually physically attacking someone, or could words be enough? Like, your mother is a this or that. Would that constitute provocation?
Yeah, great question. So one of the things that came up in that Supreme Court decision that I was talking about was the fact that the jury is supposed to look at the accused's role in the incident, and not just whether they did anything unlawful to provoke the situation. Even lawful conduct, anything can constitute provocation or can constitute a role in the incident. So anything that the accused did, every step that they take, every decision that they made is going to now be scrutinized by that jury, deciding whether they took the right course of conduct or a reasonable course of conduct when they decided to use force to defend themselves.
Interesting. So I think in Canada, when we're talking about the Rittenhouse case, the context is so different because of our different firearms laws. In Wisconsin, people can openly carry weapons, and that is not the case in Canada. So if someone did bring a weapon to openly bring a weapon to a protest or a riot in Canada, would that act in itself be considered a provocation in Canada?
Yeah, well, they're certainly not going to get off scot-free, right? Because they're almost certainly going to be convicted for the weapons offenses, right? Which didn't happen in the Rittenhouse case. But absolutely, yeah, that could be considered a form of provocation. Again, it's not going to disentitle you to claim self-defense, but it's going to make your claim a lot harder if the jury looks at your conduct and says, "Look, it was unreasonable for you to bring a weapon into a volatile situation in the first place. The fact that somebody chased you and you felt like they could take away your weapon, well, that's your fault because you started the situation." That could absolutely happen.
Yeah, and I do certainly. I mean, I have my thoughts on the Rittenhouse case, and I do think that his decision to bring a weapon to a riot or a protest or however you want to describe it, it was certainly a choice that escalated the situation that where temperatures were already really high. When we come back from this commercial break, we're going to talk about our different thoughts on the Rittenhouse decision and some other self-defense doctrines that exist only in the United States. Welcome back to Canadian Justice, where we're discussing Canadian self-defense laws and how they compare to American self-defense laws with lawyer Lawrence Gridin. Now, Lawrence, a number of U.S. states, including Wisconsin, have what are called castle laws. And these are self-defense laws. They weren't relevant in the Rittenhouse case, but they're an important part of this concept of self-defense. What can you tell our viewers about those?
Yeah, it stems from this idea that a man's house is his castle. It's the idea that if somebody is an intruder in your home, you have an extended right or an extended ability to protect yourself against that intruder than you would if the situation was happening on the street. So these castle laws, they differ from state to state, but basically they say that if someone's in your house, maybe sometimes your vehicle could be your place of business in Wisconsin's case, that you have more legal protections when you use force against that person. It's basically, a lot of them will say that it's presumed that the person who's illegally in your house wants to cause you harm, and it's presumed that your actions in repelling them are reasonable. So you don't have to, do much to establish that. It's going to be an automatic assumption that the prosecutor is going to have to disprove.
And do we have anything like that in Canada?
No, we don't have a castle doctrine in our law. But again, when it goes to assessing the reasonableness of using force to defend yourself, the fact that you're in your home and there's an intruder in your home is obviously going to be an important consideration that any jury is going to take into account. And let's put it this way: you're going to you're going to be much more likely to succeed on a self-defense claim if somebody's in your house versus the same action on the street.
Sure. Now I want to just conclude by talking briefly about Rittenhouse. As an observer, as not a criminal lawyer, I have my own thoughts. I think bringing a gun to this riot or protest is a dangerous idea. I think it's intentionally provocative, even if it didn't maybe arise to a level of provocation under the law. And I think based on the videos that I saw, I do believe Rittenhouse when he says that he was in fear of his life. But he was in a dangerous situation that he himself had put himself, he had put himself in that situation. And his own conduct escalated it. And I do think what he did perhaps is so dangerous that it should attract criminal sanction. So all of this just to say, Lawrence, if Kyle Rittenhouse had done something like this in Canada, what do you think the outcome here would have been?
It's hard to say, but I think, we have different values in Canada versus the United States. We have very different views on guns and bringing a dangerous weapon to a situation. We have very different views on the notion of open carry. So I think there's a pretty decent chance that the outcome would be different and that the jury would look quite unfavorably if they looked at, the fact that he had put himself in this situation. I agree with you, though. I mean, it's a tough situation for him at that moment, right? At that moment where I believe him too, that he feared for his safety, feared for his life when somebody is that close, is chasing him and has his hand on his weapon. there is a risk that he's going to be disarmed. I think it's reasonable to fear for your safety and to, but what are you going to do? Are you going to think to yourself, you know, uh, I'm just going to allow this person to overpower me, or are you going to take action and defend yourself in that situation? I think most people would probably defend themselves because they subscribe to the idea that it's better to be judged by 12 than carried by 6. Um, but you have to be somewhat sympathetic to, at least at that moment, the situation he found himself in and what he did. But again, he did create a situation by bringing a gun to a volatile situation, right?
Yeah, I think we're on the same page here. Lawrence, I really appreciate you coming on and breaking all of this down. This is complicated stuff, and I think a lot of people have been asking these questions about it. I really appreciate you coming on today to share your expertise.
It's been my pleasure. Thank you so much, Christine.
Thank you. We've heard today about the widely reported on Rittenhouse case from the United States and how the law of self-defense operated in that case. We've also heard a comparison of that case to Canada's self-defense laws. Straightforward self-defense has been harder to claim in Canada since the law changed in 2013. We also don't have some of the other self-defense doctrines that exist in the United States. Do you think the standard for claiming self-defense should be an even higher one than it is now in Canada? Or do you think it should be easier to claim, like it is in the United States? What might be the implications of changing it? And what kind of society would that create? You be the judge. Thanks for tuning in, and remember, a freer Canada starts with you.